Big news in the Kohberger case. The DNA issue is still percolating.
So it looks like the investigators for Brian Kohberger are able to have access to the DNA, the IgG DNA stuff.
We have a tidal wave of new documents to go over. New developments in the Kohberger case. I'm Lainey Law.
And I'm attorney Andrew Myers.
And today we have attorney Yoli Medina joining us. How are you doing today, Yoli?
Fine, thank you. Thanks for having me.
So today we are going over some new, fresh documents.
Yeah, and there's another hearing that's been scheduled for the 27th of June, in which they're going to schedule more hearings. So it's a hearing about hearings, right, Yoli?
Yeah, they're having a hearing about hearings, yeah.
So I guess the first document that we're going to take a look at is about the DNA, and I don't fully understand it, so you're going to explain it, right?
Yeah, I can read it if you want and explain it.
Okay, so here is what has been filed here in June of 2024, and it's called the Second Amended Order for Disclosure of IgG Information and Protection Order. And Yoli, you correctly pointed out that people are confused about this, and I'm one of those people that is confused about this. There was a hearing, as this points out, on May 30th of 2024, and this was the part of the hearing that was secret. The sealed order for disclosure of IgG information and protection order is hereby amended as follows. So do you want to read the rest of it for us?
I can read it. Defense counsel Ann Taylor, Jay Logston, and Alyssa Masoth, defendant Brian Kohberger, IgG defense expert Dr. Leah Larkin, Bicca Barlow, and Stephen Mercer, and defense investigators may view the IgG materials provided by the state. So just to clear that up, the additional people who can review the IgG provided to the defense experts and defense counsel now includes the investigators. The investigators can review it. Okay. So she had to seek permission to get the investigators to review it. And it says any further dissemination of the materials or the information contained within the materials must first be approved by the court after a showing by the defense as to why such individual needs the information for the preparation of the defense.
Now, isn't it strange? I'm sorry to interrupt you, but that's just the kind of guy I am. Isn't it kind of weird that, it's been a year and a half plus since the crime, and just now the defense investigators are being allowed to view the IgG materials? Isn't that a little bit odd?
It is odd because they obviously had it when they detailed the probable cause affidavit. I mean, they talked about it in there. So it is odd that they're just now letting the investigators see it. I mean, previously they allowed her experts to see it. The DNA IgG experts that are listed there, Leah Larkin, Bicca Barlow, and Stephen Mercer. But now she asked for permission to have the investigators look at it. I don't know. Before he wouldn't allow the investigators to look at it, she filed a motion and he agreed to let the investigators see the DNA IgG information. And that's why he issued the second amended order for, regarding the IgG DNA.
I have a question, just because I don't have as much legal experience. Is this standard that the investigators wouldn't initially be allowed, but now they are, that this would have to be specified and clarified?
I wouldn't know that. Only because this is a criminal case, and IgG DNA is normally used in cold cases. So this may be a matter of first impression for the Idaho court, but I'm not sure about that. I don't know. Andrew, do you have thoughts?
My only thought is, what are they hiding? I mean, it's been a year and a half plus, like I said, since the November 13th awful tragedy. And why not just let the defense take a look at it? If they have something to hide, they have something to hide, and it's a Brady violation and not allow them to see it. And if it's nothing, why not allow them to see it?
Right.
I don't see either way you look at it why this had to go to a motion, and there was a closed hearing back on the 30th, where we couldn't even see what the argument was. So if there's something to hide, they can't, and if there's not something to hide, why didn't they? So, as I said in the beginning, I'm still a little bit confused. So, what's this all about, Yoli? Additionally, no, and why don't you read that?
Okay. Additionally, no individual on the family tree who was not previously known to the defense via the defense's own investigation may be contacted by the defense or any agent of the defense without prior authorization from the court after a showing as to why such contact is necessary and material to the preparation of the defense.
Okay,
So-
let me play Mickey the Dunce and ask you, which is easy for me. Why would they want to talk to anybody else in the family tree? Why not just talk to, well, I mean, what would Brian Kohberger's cousins or uncles or, people, probably his great grandparents aren't around anyhow. Maybe they are, I don't know. But why would anybody need to talk to those people?
Well, it goes to the mitigation expert, and that's the last paragraph. But the second paragraph though is just basically saying that the defense cannot contact anybody on the family tree that was discovered through the prosecution's investigation doing the ancestry IgG family tree.
Okay.
So yeah. So here's where comes mitigation. It says the defense's mitigation expert who has created her own family tree and who does not have access to any of the IgG information may continue her mitigation investigation, including contacting defendant's immediate family members and other related individuals.
Okay, so for those people that don't understand the mitigation, and it's her due diligence, she must do this, even if she believes that Mr. Kohberger is innocent, and even if he's found innocent, she's got to prepare for the potentiality that he's found guilty. And then in the sentencing phase, there's a whole separate bifurcated part of the trial that is for mitigation. So she's got to prepare herself, and so. Now that I've thoroughly confused everybody besides myself, why would, and again, to play Mickey the Dunce here, why would the mitigation expert want to go talk to people like Mr. Kohberger's sister, who allegedly he stole a watch from?
Well, to see what family dynamics were in play, any genetic type of disabilities that might be in play, that might help understand why, if Brian Kohberger committed these crimes, why he may have done it. And maybe there are some things genetically, like in a family tree, like, for example, and I'm not saying that Brian Kohberger has this, but, if schizophrenia tends to run in families, if he had schizophrenia, they'd want to check family tree and say, this was out of his control. Or, they were mitigating things that will lessen the sentence because he is facing death penalty. And, so that's going to be what he's facing. And so the defense wants to get enough information about his background, including, his family history and family tree to see, to see what mitigating factors, like, was he abused? Did he have head trauma? So they do an investigation, and a part of that is with IgG ancestry thing. They kind of do their own. So basically, this order is saying that the mitigation witness can proceed, which I don't know why you need an order for that, but
I don't either.
Do you think so? I guess my question versus the DNA, how you were saying, like, finding someone that has like schizophrenia and stuff, because my thought with the whole family tree, because this is saying like, oh, like, you can continue with the own family tree that you built, but not use the prosecution's family tree through the DNA. I feel like things like family members and relatives would be relatively easy to figure out anyway. Like I can go online right now and type in someone's phone number and find out their like 5 closest relatives.
Yeah. So it is kind of strange that, well, it's strange that there would be an order saying that the defense's mitigation expert can continue with her investigation, because I don't think you need an
I
order
hope
for that.
so.
I don't think you need an order for that. But in order, it's saying that the mitigation expert can't have access to the IGG information that was prepared by the prosecution's witnesses. So basically, nope, you can't have our work product, because you're not, it's not like the mitigation expert is going to be contradicting their IGG experts. This is a separate issue. This is after, if he's convicted,
Right.
the sentencing phase. So it's
All
not, and I think there was a lot of confusion because people thought that this witness, the mitigation witness, was going to somehow contradict the DNA IgG evidence that the prosecution prepared or whatever they did, but it's different. So basically, it's just separating it. Saying,
I get it. You've unconfused me on that issue, but now I have another level of confusion. That was very good. Thank you very much for kind of clarifying that for me and all the other Mickey the Dunces that are out there. Okay. All right. So this allows the mitigation expert that Ann Taylor has lined up to go talk to Aunt Susie and Uncle Billy, and they can say, okay, Brian was a good kid growing up. He always, he delivered the newspaper and he swept the floor and he was a good boy. And, he, despite the incident with the watch, he was a very good boy. All right. I get it. Okay. All right. I get it. But now, including contacting defendants, Brian Kohberger's immediate family members and other related individuals. Now, as somebody that does some estate planning, that's really fuzzy. What is an immediate family member or other related individual? I mean, does that brothers and sisters, cousins, first cousins, second cousins, aunts and uncles, grandparents, great grandparents? He doesn't have any kids, but I don't know whether his sisters have kids yet. How do you define an immediate family member? Where does it stop?
Well, I think it's covered under the family tree, where it says the defense's mitigation expert who has created her own family tree.
Okay.
And who does not have access to any of the IGG information.
Okay.
May continue her investigation, including contacting his immediate family that is in the family tree that she prepared.
But it doesn't say that. And then other related individuals. Now, who are other related individuals? And I know Brian.
My neighbor.
My
neighbor's related to me.
A lot of people have significant others. Now, we don't know. Yeah. We don't think Brian did, but is a significant other a related individual? Is your best friend for life? Is that a related individual? I mean, that's fuzzy. I'm sorry.
It is fuzzy, and it's referring back to the family tree, but again, it's fuzzy though. It should have been probably specified a little better. But it says that the defense mitigation expert who has created her own family tree. So she has a family tree, and then it says, and who does not have access to any of the IGG information. So she doesn't have access to any of that. So she can continue investigating, including contacting all his family members and related individuals on this family tree. But it doesn't specify that, but that's kind of how I understand it. But if you have two people who can read it differently, then it's not very clear.
Well, as Lainey pointed out, a lot of times you can just go on the internet and type in somebody's name and you can figure out who their brothers and sisters and boyfriends and girlfriends and stuff like that are. I mean, one time we were just fooling around here in the office and she typed in my name. And we found an ex-girlfriend who I haven't seen for 30 years because the last time I saw her, she was getting on an airplane to go to Guatemala. And I'm not making that up.
I'm on my way to join the CIA. Put me on the defense team.
But her name, you could find her name when you
So-
typed in my name. Now, is she a related individual? In my view, she's not.
If I was like on
did you live
if
with
I was a mitigation expert, I'd
Briefly.
have every single person's tree. I'd be like, all right, this is Brian Kohberger's entire family. This is his friend's entire family. Like, you can find that. I can find that well if I need.
Yeah,
I'm not going
and
to.
other related individuals. That's right. It doesn't say
My neighbor, my
doesn't say-
neighbor's neighbor. Like,
that's true. It says defendant's immediate family members and other related individuals. It doesn't say.
Now, look, if I had been writing this, I would have said blood relatives to the first degree of consanguinity. That's how
There you go.
that's how an estate planner would have written this. And maybe somebody that knew something about estate planning should have written this, or they could have consulted. There's got to be somebody in Moscow, Idaho that knows something about this stuff.
You're absolutely right. It just
All right.
says, and when you're reading it, when I read it the first time, I think I tried, I understood the context of it, and maybe that's why he wrote it the way he did, but it's not specific enough. It does.
Yeah.
You should say blood relatives, non.
and that's how, like, you said, like the sanguinity or whatever. That's very specific when talking about like the IgG, like the DNA information, because then it's actually relevant people versus related individuals.
It does.
Okay.
Yeah, it just says other related individuals. Wow.
Are we done with this one? Thank you for clarifying.
Yeah, I think we're done.
All right, are we done with that? Should we go to the next one?
Yeah.
This case is just it's the gift that keeps giving. Look at this one. The order setting a hearing. Here's a hearing for more hearings. The scheduling hearing is now set for June 27th at 10 o'clock in the morning Pacific time. This hearing will be open to the public and will be live streamed on the court's YouTube channel. Counsel shall be prepared to address scheduling dates, including a briefing schedule and oral argument dates. See that, plural, for pretrial motions, plural, including motions, plural, to suppress, motions, plural, in limine, and any motions challenging the death penalty, expert disclosure deadlines, a trial setting, deadlines for filing pretrial materials such as proposed jury instructions, juror questionnaires, witness lists, and exhibit lists, and sentencing disclosure deadlines.
A plan for making plans.
Now, what is that? Okay, I'm not trying to give people a hard time, but down on the third line where it says a trial setting, does that mean the trial date?
That's what it sounds like. But the way this court is going, I don't think they're going to get all this accomplished in this hearing. Like, I don't know. I feel like this has been said before, and things are going to change if the motion for change of venue is granted and it moves somewhere else. I think that this is going to change. I would think, because it's going to be in a new court, and I don't know, maybe it won't change, but it seems like we've gone through this before and it just never goes through because something subsequent to this hearing, to the hearing setting the dates, occurs. When they had the change of venue hearing, they had this scheduling order and everything. And then prosecution has brought this motion that they're violating the gag order with the survey questions. So we had to have a whole day hearing about that.
Yeah.
And then now the motion for change of venue is moved to August. And
End of August.
End of August.
I forget whether it's the 27th, but it's the end of August. Yeah.
Maybe this is just the court trying to move the case along and trying to, I don't know.
Yeah, there's been a lot of criticism, especially Mr. Gonzalez has said that what was his quote? He felt like it was a spinning wheel or something like that. That it just keeps going on and on and on. And I'm sure the other family members aren't happy. A lot of people are unhappy. We see it in the comments go both ways, but some people are just saying, why is this? Just take it to trial. We know he's guilty. Just try him today. So, I mean, I don't know whether the court feels like it's under a little bit of pressure. There was one article which I meant to download, but I guess we'll do it another time, of one legal expert out in that area saying, look, and we've said this before, but he's saying, look, not only is it a death penalty case, but it's a complicated case that's going to have a lot of electronic and, other kind of evidence. And it's just going to take time to get it set up. So, I don't know.
The bottom line is the electronic data, phone pinging and everything, it doesn't show you a location of a person. I mean, it shows you a location of a phone.
True.
And is that enough to prove beyond a reasonable doubt?
Yeah, good point. That's a really good point.
I don't know if it is.
And maybe part of this was because people were tuned into that news network that actually ran a series a couple of weeks ago that said when the case is tried on March 3rd of 2025, and they actually did a thing and they put it up on the screen on their Chiron that the trial is set for March 3rd of 20. And it's not. The trial is not. Yeah, go down in the comment and tell me, I've seen that on this channel. Well, it's rubbish.
That's true.
It's
That's
not.
true.
All right. So all these things, it just seems like there's a lot of dates coming up. A lot of dates.
And it's so many that how can you even, do they even know how many motions in limine they're going to have? Do they even know how many pretrial motions to suppress they're going to have?
I remember about a month, maybe 6 weeks ago, Ann Taylor had mentioned that there are going to be motions in limine, and there are going to be a number of them. I think that's what she said. There are going to be a number of them, and then she mentioned those 3 cases that at one point I summarized in a different episode. All of them talk about the reliability of informants. So, there's going to be motions in limine, but I don't know how they do it in California, Yoli, but my experience in the courts that I've dealt with generally is that a trial date is set up and then you work backwards. The trial.
That's how it is.
Okay, so the trial date is on a given date. Then you backdate, for final motions in limine. Then you backdate for expert disclosures by one of the parties. Then you backdate. It all falls into line. But you really kind of sort of have to have, if not a date certain for the trial, you've got to have a general idea of when it's going to be.
Procedure, yeah. It's a procedure to keep things, But here I feel like it's a wild, wild west. It's just like whenever they decide. That's why I'm so confused about the procedure because, like you say, normally here in California, we have a trial date. And then there are dates like 50 days before trial. We have to exchange experts.
Right. And that's in the rules.
Yeah, it's the rules. Yeah. And so you work off of that, even though the trial may not go, that's what you work toward. And so, it's a procedure, kind of like we talked about the alibi procedure.
Right.
It's a procedure, but I feel like this I don't know. I just feel like it's just random.
It's up in the air. All right. What other gems do we have here in the docket in Idaho? We have a temporary order sealing Exhibit 1 of the state's 3rd supplemental response to the defendant's 5th motion to come. Are you keeping track of this? Okay, this is just the temporary order sealing Exhibit 1 of the state's 3rd supplemental response to the defendant's 5th motion to compel discovery pending hearing. So I guess this is their response, but it doesn't say anything. Here's another gem that is on the docket right now in Idaho. The state's 3rd supplemental response to the defendant's 5th motion to compel discovery. And it says, comes now, state of Idaho, by and through Latah County prosecuting attorney, and submits the attached Exhibit 1 in response to defendant's 5th motion to compel discovery, filed on April 15th, 2024. The state incorporates the following responses as fully set forth at this point. So the state is incorporating the following responses as fully set forth at this point. And then it has this whole litany of bullet points of things that were filed on January 23rd of 2023, February 21st of 2023. And I'm not going to read them all, but Yoli, does this just mean that the state prosecutor's response to the motion to compel is, hey, look at all this stuff we already gave you. Look at all these bullet points. Is that what this is? And they're producing nothing else?
Yeah, they're just basically saying we already provided all this to you. It's kind of like to me, it just seems like it's kind of like what Ashley Jennings was saying that, look, we provided all this, we provided all that, you know.
Right.
Yeah, so they provided a supplemental response on May 28th. The last bullet point says,
You passed it.
it says, state second supplemental response to defendant's fifth motion to compel discovery filed on May 28th. So they did file some kind of response, but it's under seal.
So there were some new documents that they filed, but we have no idea what they were. And they cited those usual 4 reasons to protect the integrity of the investigation and to protect. The one interesting thing that they said was to protect any informants, any confidential informants. So I don't know. So that was kept secret. The thing that I find interesting, and tell me if I'm being too much of a nitpicker, the thing I found interesting was that it's, as we record this, it's now been a couple of weeks, more than 2 weeks actually, since the hearing on the 5th motion to compel. There's been no order by the state. The state
it seems like they're producing information according to the motion to compel, but I haven't seen an order telling them they have to produce it.
Yeah, that's what I was saying. You said it more eloquently than I did. It's been 2 weeks since the hearing, and yet there's been absolutely no order by the court. Is the court just saying, yeah, you guys work it out?
It's what it's, well, they've already produced some information responsive to what was in the motion to compel. That's what I understand. So I don't know. Maybe, like you say, the court is saying just work it out. But I would think the motion to compel requires an order. At least that's how it works here.
Yeah. If there's a motion to compel, you're asking the court, we want an order compelling production of the following documents. And during that hearing, the judge was writing down on his notepad, okay, item 236, item 285, whatever. And I felt that was leading towards some kind of an order, and that never really happened. There was never an order. So anyhow,
but they are producing some information.
Well, that's fine.
On one of the documents, it said pending hearing, and I don't know what that means.
Well, yeah, you're right, and that's all well and good for the state to say, okay, we'll give you more stuff, but there were specific things that Ann Taylor and Elisa Masoth were saying, this is what we need. This is what we want. We want the Vizcast log. We want, the actual subpoenas themselves, not just the returns that have the documents, because the documents don't tell us the time frame within which those subpoenas sought the documents. So we want those things. And Elisa Masoth threw her hands up during the hearing and said, we feel like we're in a snow globe because, we have all this stuff, but we're not getting the stuff we want. So in our last episode, said I felt they were being snowed. I felt it was a snow job because, the response that Ashley Jennings had was, we've already given them 34 binders and 4 tower dumps, and she went down from 51 terabytes to 50 terabytes. And, so, I mean, it's all well and good. If I write you a request, Yoli, and I say, I want X, Y, and Z, and you just throw a bunch of crap at me, A, B, C through W, that's not what I want.
None of which is responsive, right?
Right. That's what I'm saying.
Yeah.
You always say what I'm thinking more eloquently.
Yeah. So what the court should do, I think, and I mean, procedurally is how, there should be procedures. He should issue an order ordering them to produce that information, because if they're just turning it over without an order, can they object at trial and say, Your Honor, we produced this because there was a motion to compel, but you never made an order?
Well, I guess an argument could be made both ways. The argument would be, well, we did produce it, but if they don't produce it, I would hope that at trial there would be an order that they may not present evidence that they've withheld. And I know some of our commenters below, and we get into viewer comments later on sometimes, our viewers have said, the discovery deadline isn't until September. So why do they have to wait? Well, they have to do it now because often you get things in discovery that lead you to have more questions. And so that's why there is a cutoff in September. But they need to present that stuff now under the Idaho rule of criminal procedure 16 in Idaho. When there's a request, the stuff has to be given to you in 14 days. So that's why you don't wait until the final deadline.
Yeah. And
Thank you.
just because something is discoverable doesn't mean that it's admissible, you know?
Right.
So you get information that's discoverable, and then that may lead you to information that is admissible.
Exactly.
So that's the whole reason why you have the deadline in September, is for that process to work itself out, you know? But if they're not giving you anything, and then they give it to you September, and you find that you need more from that based on what they gave you in September, you find that you need more information and discovery is cut off, then how can you get that information?
Exactly. So a good example would be I send you a request for all correspondence between A and B, and you send me the correspondence between A and B. And the reason I need it immediately now within the 14 days in Idaho or 30 days in my jurisdictions is because you send me that correspondence between A and B. And I actually sit down and read the correspondence between A and B. And it turns out that C is potentially liable, shares liability. So now, I only have until September to bring C into the litigation and start discovery against them. So that's why, dear commenter that says, they have until September, that's why it's really important to get the discovery early on in the phase. So when additional information is raised, you can act upon it.
Yeah, and it's not, yeah, and that people need to understand that what is discoverable, all this information may be discoverable, and maybe, you know, they get to look at it and it's a whole ton of information. That doesn't mean that it's actually admissible at trial.
Right. The distinction, let's have a real litigation conference here, really. The distinction between what's relevant and that which is relevant, only that which tends to make an item that is of gravity in the case more or less likely. But that's a very narrow standard. The standard for discovery is whether something is reasonably likely to lead to the discovery of evidence admissible at the time of trial. So this is relevance and this is discovery. So I don't know how they do it in California, but that's how my jurisdictions do it.
That's how it is. Yeah. That's how it is in California.
Yeah, that pretty much comes from the federal standard. And I think Idaho might be a little bit different. I think they might be a little bit different, but I think that's generally universal, that the standard for discovery is anything that's reasonably likely to lead to the discovery of evidence admissible at time of trial. So it's a battle, and I'm surprised it's still going on. But then again, maybe I'm not so surprised because, you know, in the Reed trial that we're talking about, they were going back and forth quite a while. And one of the attorneys, the defense attorneys, filed a document that was 97 pages. And, you know, so I don't know. It just seems like the Idaho case is off the rails, and it's going to be even more off the rails with all of these hearings. But anyhow.
Keeping track of these hearings, I mean, it's like the Wild Wild West. There's just something pops up.
Yeah, and keeping track of all the documents is kind of a challenge too, as we saw me before, kind of looking around for all these documents, and there was a new one to me anyhow.
Yeah.
I know we've talked about all the issues with sharing and how it's not anything super uncommon, but I kind of agree with you where it's just like, just give it over. It's like, I don't understand why this has to be so convoluted. And like you're saying, you should have ample time to be able to prepare and stuff like that. And I don't know. I don't necessarily see how it helps the prosecution to be this difficult with everything. And it does strike me as if something's wrong because of it. I don't know.
Yeah. Well, it does too. I mean, it's strange.
One of the questions that I get a lot is, and I get both questions. I get, do you really think that Kohberger's team is doing a good job? And the other question I get is, isn't Kohberger's team just dragging everything out? And I tend to think that I think they're doing a good job. And I don't have any skin in the game in terms of, I don't know Ian Taylor, I don't know Jay Logston, I don't know Eliza Masoth, but they seem to me to be doing a fairly good job. I mean, they all seem very articulate. They all seem, like they're on their game. Ian Taylor is I hate to use the analogy of a dog with a bone. I hate to use that analogy, but she certainly is pursuing every possible avenue. This DNA thing, I can't believe it's going on this long. I mean, it's been since.
Well, it's because they say they're not going to use the IgG. They're not going to use it at trial. Okay, but that was part of what they used to investigate Brian Kohberger. So the question is, how did you get to Brian Kohberger? Please tell me.
Right.
And I don't know that answer is clear cut. It's not to me as of yet.
No, I don't think it's clear to anybody that's following the case closely. And why are they? I said it earlier, but I'll try and say it with different words this time. Why are they hiding it? If it has nothing to do with the case, let them have it and let them waste their time. Let them waste their time. If it does have something to do with the case, all the more reason why you shouldn't be hiding it. And why is Mr. Thompson just hiding all this stuff? Why has Mr. Thompson been so quiet at these last couple of hearings? Do you have any insight on that?
Well, he's quiet because he at some level doesn't want to be implicated in this. In whatever's happening, or he's letting the junior attorney get experience. I don't know.
I don't know either.
I don't know. I think he's quiet because, it's kind of like at one of the hearings where the judge admonished him and said, "Hey, and then he was quiet after that." It's kind of like he what is he going to say?
I don't know. I've been lightly admonished, never scolded, but I've been lightly admonished by judges before, and I didn't shut up. I certainly took note of it, but I mean, I didn't just sit down and sulk. You say, the judge is kind of giving me a guidepost, Mr. Myers. Don't go beyond it. Okay, but I'm not going to sit down and sulk for the rest of the case. I mean,
it's bizarre.
I had a judge tell me one time in a personal injury case, in the middle of the trial, the judge pulls me over and he says, "Mr. Myers, what are you looking for in this case?" And this was over at the bench away from the stenographer. And I told him what I wanted. He said, "Mr. Myers, come down out of the stratosphere." And then he told the defense attorney to come up out of the gutter. And we finished up the case, and he gave us a good judgment. But I mean, so there's an example of a very well-known judge in Boston. Everybody knew the guy at the time, and he kind of gave me a little bit of a, but I didn't take it personally. It's like that, he's a judge. He's tried a million cases, and I had to respect him, but I didn't go back to my table and go, "I'm not going to talk anymore," because that's my job.
Does this, all the difficulties with everything going back and forth, if he were to be found guilty, is this going to impact their ability, or how successful an appeal is? If they can be like, "Listen, the prosecution was blocking us at every turn. We kept doing this and this." Does that have any standing? Would that impact it at all?
I mean, it can, but mostly what happens at trial is what is mostly appealed, not the pretrial. But there are some pretrial, like for example, if the judge allows certain evidence to come in that wasn't produced in a timely manner and it was prejudicial to the defendant, then possibly that might be an appeal, but it just depends on what the evidence is. You know what I mean? But mainly it's like trial objections and trial evidence coming in at trial, but it certainly could be before trial, like in trying to get information.
I think partly, and that was a good answer, but I think I would also, in addition to what you said, I would say in answer to Lainey's question, and that she's, talking for our viewers, if we get into the Kohberger trial and the prosecution tries to bring up evidence that they've been withholding all this time, then we've got an issue for appeal. If there's not if the court allows that evidence in. So yeah, all these evidentiary things, if they percolate over into the trial, yeah, they absolutely can be a problem. Most appeals, are based on erroneous rulings. Evidence shouldn't have gone in that did go in, or an objection that was sustained that should have been sustained. That kind of stuff that happens at trial, or problems, with the jury. But yeah, but all these pretrial things are really crucial. It's kind of like building a skyscraper. Right now, we're building the foundation, and if you don't build a strong foundation, the skyscraper is going to fall over. So yeah.
Right now, I don't see the foundation.
No.
The initial, how did you come? They have the white car, but no license plate, no nothing. They don't have, that we know of, have.
They changed the year.
I mean, I just don't know. And it could be because things are sealed and we don't know. But, certainly what was in the probable cause affidavit is turning out to be kind of a flop, at least the stalking and the opinions in there. But
yeah,
we
went over the one thing in our previous episode that we did with you, Yoli, where the viewpoint of the writer of the probable cause affidavit was changed in one sentence. In one sentence, it's the Washington State University officers, and then at the very end of that same line, all of a sudden we jump a month and it's Brett Payne's view, and it's like that's
misleading.
That's deceptive.
It is. It's misleading because you have to really be. I mean, after reading it so many times, I think I finally caught it. Like it's like it is misleading. And you should always write an affidavit as a declaration as I did this, I did that, I did this. Right. Based on my conversation with so and so, if they're going to use hearsay.
Right. You took words out of my mouth. If I'm writing an affidavit that we're gonna convict Lainey Law based on my observation that she did this and she did that, and she and based on a telephone call that I had with Yoli Medina, I learned that. So I'm stating a fact, and I'm giving the fact that it was a source. But
on such and such date, I learned, and
exactly
the date is absent. It's like there's an absence of specificity in that.
An affidavit is supposed to be short paragraphs, concise paragraphs, with dates and times and facts. And each paragraph is a fact. So if you write an affidavit with 14 facts, you have 14 different, sequentially numbered sentences. And the more I go back and, I'm late to the game on this, I think I'll admit it. But the more I go back and read the probable cause affidavit, the more horribly it is written.
And then they have these maps that you can't even. They have maps in the entire, like inside the declaration, and it's like, okay, I don't know. It just seems very poorly put together, and I still don't know how they pinpointed Brian Kohberger. They first said he was stalking them, and I assumed that the phone pings won't necessarily establish him stalking because the phone pings don't track a person; it tracks a phone. So they could say the phone was stalking them, assuming, we assume he has his phone. So you can assume, so he was there 12 times in the area. Okay, in the area, what does that mean? In a 6-month period? I don't know. Or 4 months.
I don't know. Last week I forgot my phone. I left it on my desk. I got all the way to the gym and I went to listen to my music and I didn't have my phone. So I mean, I could have been off doing other things.
Or even like the parking lot thing, like we've talked with CJ in the past. If you're going and you're parking the car behind this house, maybe you're leaving your phone and going for a walk.
Right.
It just, like you said, Yuli, it's like just because the phone is there doesn't necessarily mean the person's there.
Yeah.
Right.
So, I don't know. We'll just have to see.
Yeah. Okay, Yoli, thanks for joining us again. This was a great episode. Anybody have any closing thoughts, or should I bring down the gauntlet?
Yeah, I don't know. This is messy.
Bring it down.
Complicated. I don't understand it. I don't know why everything seems so difficult.
Have a good week, everybody. You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertisement in some jurisdictions.
And that's that.
And that's that.
And that's that.
Recycle your plastics. Share evidence.
We were talking about recycling. You recycle?
I do.
Oh, good. Okay.
Do
I
you
do.
have to go to the recycling facility, or do you have bins?
No, I have been.
Oh
Have
yeah,
been.
no. We were just talking about how both of us today actually went to go physically recycle at the physical dump.
You don't have the bins that the trash people give you?
No, I have my own bins that I keep in my house, and I gotta drive them over. And usually my bins are completely overflowing, and I got a cardboard box filled with cardboard next to my cardboard bin.
My
Our
town
trash
is
company.
is so cheap that we pay tons of property taxes, but we don't even have town rubbish removals. So you can pay for it, but I'm too cheap. So a lot of people are like me, and we actually go to the town recycling facility. Now we all call it the dump, but yeah, you have paper and plastic and cardboard and metal and newspapers. And today I had some metal I had to dump in the metal pile. So yeah, we actually go to the recycling center and put all this stuff out. And I'm a good doobie. I do it.
It's so bad. They know me too well.
I think I pay a little bit to have them come take the trash out. They give us the trash bins. It's like a nominal fee.
We're New England Yankees, A, and B, I'm too cheap, and C, I have two offices and a home I have to pay all these bills for. And so if I can reduce my bills by one bill, I'll do it. So I don't want to pay to have somebody take my trash when I can take it myself. The trash place, the dump, is like not even a mile from my office here. So it's kind of on the way to work. But the other benefit is you get to see what a bunch of drunks all your neighbors are. You see them falling in.
That's me.
These recycle bins full of Budweiser cans.
And it's so embarrassing too, because I don't even drink really. It's just like after like 2 drinks, my stomach hurts, I'm knocked out. But I'll have like 10 people over, and I leave the recycling, so it's just like there'll be 2 parties. So I'm going to the recycling facility. It's just me carrying this giant container filled with all these different beers, and the people come out. It's like, oh, hey, how you doing?
No,
how's your family? I'm like, oh my god,
no, not one.
giant vodkas. Like just throwing everything out. Every time I'm going to the recycling, I dump it, and I'm like, oh, that's interesting. Like that's not.
I just have a lot of boxes in my recycling from deliveries. Boxes of things like
My town actually makes money on cardboard. The cardboard they make money on. So people say, "Oh, let's reduce the use of cardboard." No, send me tons of cardboard because the town sells it to a facility that does whatever they do.
Yeah.
They recycle it, and then they they make money. So yeah, send me your cardboard because I want to reduce my taxes if I can.
Don't send me any cardboard. I don't want to go to the recycling center. They recognize me. They know me, and they're definitely confused at all the stuff I'm dropping off.
How weird.
But you do get to see.
Everybody here has trash bins and recycle bins, and they actually have green waste bins.
Yeah,
it's definitely because I'm from New York initially, and in New York they have the recycling bins and everything. But I've lived in 2 places that have like a disposal bin. But right now the trash comes once every week. We have a little HOA and we have to put the trash out on the corner. We don't even have a dumpster to put our stuff. It's rough out here in New England.
No, we're very Yankee like here because I used to go to the recycling facility, I'll call it now, on Saturdays because that's my day off. But it's so crowded, you actually wait in line. Your car is in line at the recycling facility, and it's like, so now I do it on a Friday before work, and especially on a rainy day, there's nobody there. So I love rain. I love rain. I love rain for a lot of reasons. One is that if I go to the dump on a Friday morning on a rainy day, there's nobody else there, so I just zip right in and out of there. So
talk about having to think about getting rid of trash was just another level.
It's no big deal, and tons of people do it. Even this morning, it's a Friday morning, and it was about ready to rain, and there were a lot of people there. There were a lot of people throwing their stuff, and it's an opportunity. Sometimes you see people that you haven't seen for a while. You get to jibber jabber with them, or you see somebody, they say, "Give me a call. I want to talk to you," or you see some poor
networking, some networking.
Yeah, or you see a senior citizen and you don't mind helping them. They have their bins, and you don't mind giving them a hand. So it's not a bad thing. I mean, it's just one of those things, and a lot of people say the same thing. But anyhow, all right. So, I'm not. California has kind of led the nation in all of this stuff, I believe.
The recycling and all that, yeah.
Yeah, you guys have kind of led the nation. Although I know, I'm from Pennsylvania originally, and I know 30 years ago my parents were telling me that they were doing all this stuff. So Pennsylvania's kind of been in the.
No, I've only lived in California and Orange County for most of my life. I lived for 6 months in St. Croix, Virgin Islands.
Oh wow!
Yeah,
nice.
It was for work.
Oh, okay.
Related. Yeah, it was nice.
I've lived all over the place, but yeah, recycling is pretty much of a constant thing now. We've never talked about politics, and I'm not asking anybody to, and I don't necessarily agree with her, but Greta Thunberg actually did a really fascinating thing traveling around the world and talking to people all over the world, Europe, Switzerland, England.
Yeah, she did.
Canada. Do you know the one I'm talking about?
Yeah, she's outspoken. I think she has she's on the spectrum, maybe.
Yeah.
I thought that she said that. So she's like really outspoken and.
Yeah. So you can say what you want to say about her politically, and not everybody agrees with the stuff that she's done and her techniques and her tactics, and that's fine. But she did a thing that's on Hulu, actually, I think. And it's a couple of parts, and she goes around and she talks to people about what they are doing, not just this, blah, let's be green and hold signs and shit. She talked to one really interesting guy that they have this plant, and I don't know the name of it. I'm not prepared for this conversation. But what it does is it's this great big, huge fan generator that pulls air into it and pulls carbon dioxide out of it, and the product is like a carbon pellet, a big carbon pellet, and then they bury them deep in the ground. And it's like, it's a very early technology, but if you had a billion, zillion, million of these, it would put a dent in the problem. It's just a fascinating thing. It's a fascinating thing, and recycling has always been interesting to me. I mean, I could go on forever about this, and that's not what this is about. But recycling is interesting to me. I think we should do more of it.
It's important. Recycle. I said it's important. Recycle. As if we had the Merrimack. I want to say it was Merrimack. The plastic. They had like a plastic manufacturing plant in there that they had to shut down. And it's like you look at the reviews on Google, and all of it's like they're poisoning our water. So, even though we're recycling, the impact that we're going to have isn't as big as other companies like that. But, I mean, the ocean, we have Texas of plastic floating in the ocean right now. So every bit,
By the way, in the Idaho 4 case, there's a big recycling plant, a big recycling place there.
Where?
Near the tower.
What tower?
The tower that says Idaho.
Really?
The water, is it a water tower or something?
Yeah, the one that says Idaho or I on it.
Yeah.
Really?
Or Moscow or something. I don't know what it says. But yeah, there is a recycling plant there that a lot of ex-cons work. They work
really?
there.
I did not know that.
Yeah, there is. There's a couple of people who did boots on the ground that talked about it.
Really? Oh, wow. Did CJ do a thing on that?
No, not on the recycling. No,
Okay.
but a couple of other people did.
Did that JLR do it? JLR does everything.
If anybody would, he would.
He's very out there.
Yeah,
he is out there. He was out there for that Calvacante search, and
yeah.
remember that prisoner that took off in Pennsylvania, and they had.
I remember it very well, and that's where I said, JLR. You're right. He's a really interesting guy, and I'm from that area. I'm from Lancaster, Pennsylvania, which is right next to Chester, Pennsylvania, where that whole thing happened. And Longwood Gardens is a place that I've been by a million, billion, zillion times.
Mm-hmm.
It's a very popular tourist place in that part of Pennsylvania because it's a huge garden area. It's a huge area. I've never seen anything like it since I moved to New England a long time ago. And JLR was really interesting, following the cops as they surrounded the whole place.
She's somehow there.
And that's the first time I really listened to the guy. And I said, he's got a Pennsylvania accent. And sure enough, he's from that area of Pennsylvania. And I'm from Lancaster, Pennsylvania. He has that Pennsylvania twang that you can kind of pick up. And so I tried to get him to come on, and he won't come on the channel because he's too big for us. We're little and he's big. But he did, when I emailed him, he did let me use some of his footage. Remember, we used some of JLR's footage
with the dogs.
He was going up and down the little back roads, some of which I knew because I've been on them. I had a girlfriend down in that area of Pennsylvania, so I know that area kind of, sort of. And he was going up and down these roads and talking to some of the locals in their pickup trucks and the gun racks in the back. And I'm like, I think I've been on that road. That looks really familiar. So he's all right. He's a character.
Does the border things. He's out there at the border. One day he's at the border. The next day he's in Idaho.
Yeah.
I don't know.
He's been everywhere.
I don't know how anybody has that stamina to be traveling all over the place constantly and making content. And
well,
at the same
he's
time.
a guy. He doesn't have to pack all his shit.
No makeup bag.
Oh God,
no
curling iron, and I mean, he doesn't. It's just like a razor and
shorts and a pair of jeans.
Yeah, I mean, get up and go. It's like sometimes I wish I was a guy. I don't have to worry about all that shit.
He's probably got a bag packed and ready to go. Mm. So if he turns on the news tonight and sees that there's been a big storm in Oklahoma, he'll be there tomorrow.
He's funny.
He's a character. I like him. He's a character and he has a past, but a lot of people have a past. The only thing that's important to me in life is future. And I've invited him to come on, and if he's watching this, which I doubt, I know he's big and we're little, but I'd love to have him on and talk to him about some of his experiences. We don't necessarily agree on the Idaho 4 case, but a panelist that we have on here all the time, and I don't agree, but we get along personally. It just, it goes back to something we said before, maybe in the other episode that we did today. But, just because you disagree with people doesn't mean you can't get along with them. For God's sakes, that's crazy. That's crazy.
Yeah, it's silly.
All right. So anyhow, I guess it's time to bring down the gauntlet. No tunnels.
No tunnels.
Okay, no tunnels. That was funny.
All right, Yoli. Thank you. Okay.
Thank you, Yoli. Nice seeing you as always.
Bye.
Bye.